the preliminary instructions that Judge Sarek just gave you reflected the state. It's not necessary for us to present additional evidence in this case. What we expect to do in order to carry our burden of proof, and I want to remind you, and we accept it wholeheartedly, that we do have the burden of proof. We do have the burden of proof in this sentencing phase to establish for you beyond a reasonable doubt that the aggravating circumstances that you found previously outweigh beyond a reasonable doubt any mitigating factors that you may hear. We're not entirely clear what all those mitigating factors may be, but the state believes and submits to you at this point that when we stand up and tell the judge, as he just indicated, the state moves to admit the previous testimony of all witnesses we called that bear upon those aggravating specifications, that we move to admit all exhibits that previously were back in the jury room with you in phase one, that bear upon those aggravating circumstances, that we expect that those substantial aggravating specifications that are functionally the counts that we have alleged and you found in the indictment, that of aggravated robbery that began on 3rd Avenue outside of Bodega when Reagan Tokes left that night, and ended the aggravated robbery when the defendant drove out of Scioto Metro Park in Grove City in Reagan Tokes' car. Because you'll remember the definition of an aggravated robbery was a theft offense. There were multiple theft offenses constituting the aggravated robbery, commencing with the carjacking on 3rd Avenue, commencing with the attempt at Chase Bank to obtain $200, which was denied, and then the attempt at Huntington, which I think was for $500, which was denied, and then a second attempt at Chase that was successful, the $60 that was taken from the Chase drive-through by Ms. Tokes, who was driving the car, and later items, even the purse that was given within 2 hours to his girlfriend, Hatisha, that you heard him. All of those are theft offenses. All of that constitutes that aggravated robbery that began with the carjacking. The kidnapping also spans the entire 2 hours and 13 minutes that the defendant kidnapped her, again off the street up on 3rd Avenue, at gunpoint, the gun that was in his puffy jacket up at Tawana Richards' house, the gun that he threw in the sewer later. At gunpoint, he kidnapped Miss Reagan Tokes, and that continued again for that 2 hours and 13 minutes from 2:45 until 11:57 when he pointed the gun, pow pow, in the as he described, at her head, a contact wound in her left temple. The other shot, as we remember, the back of her head. So that kidnapping continued from the time of that carjacking all the way until he again committed that crime as he marched her from her car out to that isolated field that we all visited. The third aggravating specification that we alleged and you found is that the defendant raped her. And that, again, is a powerful aggravating specification that the state relies on to carry our burden of proof. We aren't entirely sure what these mitigating factors are that you're going to hear in this phase. I believe that we heard during voir dire, and if we harken back to that voir dire and that board we had up here with the scales of justice showing aggravating circumstances on the left side and the mitigating factors on the other side was an equipoise. At this point, the state has aggravating specifications on that left side and continue to have that burden of beyond a reasonable doubt to show they outweigh whatever you may hear, but the kinds of things that we heard in voir dire and in discussion with you in groups of 6 as we went through that board were things like poverty, things about poor childhood, things about folks in the family that may drink, things like folks in the family that may use drugs. Those kind of things are very prevalent in our society, very prevalent even in Mr. Golsby's home, very prevalent about other people that may have some problems that you'll hear about his upbringing. Yet those other people don't commit aggravated robberies, rapes, and kidnappings. And they don't shoot a poor young woman in the back of the head twice. So the state will submit to you in closing argument that those three powerful, very powerful aggravating specifications substantially outweigh, beyond a reasonable doubt, any information that you'll hear about this man's upbringing. And as the judge just advised you, and we talked about on voir dire, the state, if we reach that point, and 3 weeks ago I told you that in that back room that you would have that hard decision that no one seems to think isn't a very difficult decision, but that the state, if we prove beyond a reasonable doubt those aggravating specifications outweigh the mitigating factors, the state is entitled to. And the court just instructed you that if you make that finding, you must find that the only appropriate punishment is a verdict of death. And we ask each of you on voir dire, could you sign that piece of paper making that hard decision, reflecting that judgment? And you all promised us, and you're serving because of that, that you could do that tough job. And so the state expects in closing argument, when you hear all that evidence and information, that we will have carried our burden and we would be entitled to the only appropriate verdict in that case, and that is a death sentence. So thank you for your attention.
Defense.
Thank you, Your Honor. Good morning. In the last phase of the case, the judge gave an instruction of law that says you can't base your decision on sympathy, bias, or prejudice. And you're going to hear at the end of this case he'll give you the same instruction. And so I've been asking myself over the last several weeks, if the jurors can't use sympathy, then how can they consider the mitigation? Because when we were doing the voir dire, it was the question that we asked of each and every one of you. Not only would you be willing to listen to the mitigation if and when we got here, but the next question that we asked each and every one of you is, would you be able to consider it? And so I've been thinking in my mind, like, how do you consider something if you can't have sympathy for it? And members of the jury, I submit to you is because the law prevents you from using sympathy, but the law does not mention anything about empathy. And let me talk about that a little bit. Mr. O'Brien just stood up here in his opening statement and he said, the poor young woman. That's sympathy. He's trying to evoke sympathy. Sympathy you can't base your decision on. Sympathy is when you feel bad for someone. When you see a woman without an arm, an amputee, and you say to yourself, oh, I feel bad for her. Empathy is when you see that woman and then you notice she's standing next to a child and you think to yourself, what would it be like for her to never be able to put both arms around her daughter? That's empathy. Empathy is when you see a homeless person on one of those cold winter days we were having last week. Certainly I saw a number of them as I walked to the courthouse. Empathy is when you see them sitting on that cement cross-legged with their cardboard sign and saying to each and every person, God bless you, as the people walk by and not even acknowledge them. Empathy is saying to yourself, what would it be like to be that person? To sit on that freezing asphalt for 8 hours. To have my viewpoint for those 8 hours as people walking by me in new shoes, nice pants, dress socks, high heels, no one paying attention to you. What would that feel like? Sympathy is when you feel bad for them and you give them $1. And so as I was thinking through this, Mr. Gotterdam and I ask you to use your empathy. Because you can't use your sympathy. The law says so. But empathy is when you put yourself in another person's shoes. And so now is that time. We talked to you in voir dire about if and when we got here, if you would listen and fairly consider the mitigation that we gave to you. And so I want to talk about Brian's story. And I know throughout the several weeks in trial, he was always referred to as either Mr. Golsby, or sometimes people said Mr. Golsby. But it's Brian. He is a human being. He has a pulse. He eats, he walks, he sits next to me at the counsel table. So I am going to refer to him throughout this proceeding as Brian, because that's how I know him. That's how we know him. And our experts and our witnesses will refer to him as that too, because that's the person that they know. And so let's talk about his story. Brian was born in January 1988 to a 17-year-old mom that was still in high school. The father listed on the birth certificate was David Woodfork, a man that Stephanie had had sex with numerous times, not a man that she was in a relationship with, and certainly what the evidence will show, not a man that participated in either her pregnancy or the life of Brian Golsby. At one, Stephanie then, when Brian was one, Stephanie then had two more children, twins, Kristen and Christopher, with a different man, similarly to David Woodfork, another man that she didn't have a long-term relationship with, didn't live with, but that she had sex with and had two more children. When Brian was 2, Franklin County Children's Services, the records will show, first opened a case file on Stephanie Golsby. All 3 children are removed from her home when Brian is 2 years of age, and the twins are just 1. Franklin County Children's Services, the records show, will find that Stephanie was guilty of dependency and neglect of all 3 children. The twins go to their dad, Robin Smith. Brian, without a father willing to take him in, is placed in foster care for the first time at age 2. With all due respect, members of the jury, I disagree that the story that you're about to hear is prevalent in all of our lives. At age 5, Stephanie beats Brian with a belt and electrical cord on his ribs and back. Brian sent to Nationwide Children's Hospital due to his injuries, and his mom, by the state of Ohio, is charged with domestic violence against her own son. The complaint filed against Stephanie reads, quote, knowingly cause physical harm, to wit, strike about the body with a belt and electrical cord to a family member. That family member at age 5 is Brian. Brian is removed from his mother by Franklin County Children's Services, but Brian, without a father willing to take him in, for the second time in his life, goes to foster care at age 5. At age 7, Stephanie becomes addicted to cocaine. Cocaine on top of the alcohol that she already had an excessive problem with. At age 11, Franklin County Children's Services is called back into the home upon a report that she was regularly beating Brian with a plastic jump rope. Not just for discipline, though. She would use the plastic jump rope as a means to humiliate Brian. The records will show, and our experts will testify, that when Franklin County Children's Services interviewed her, she said yes, she did beat him with the plastic jump rope, but she only did it regularly to discipline him, not to humiliate him. Once again, Brian is removed from the home at age 11. Brian, without a father willing to take him in, is placed once again in foster care. He's then later returned by Franklin County Services right back to his mother. At age 12, Brian is anally raped by a neighbor in a local store. He runs home and he instantaneously tells his mother. His mother does not call the police. Instead, the way that Stephanie handles the situation is she puts Brian in the car and they drive around the neighborhood searching for the perpetrator. At age 13, Franklin County Children's Services closes their referral case on Stephanie Golsby because she is unwilling to engage in family counseling. She will not participate in other community-based services. They say she's just not cooperative. At age 13 that same year, she then files an unruly charge against her own son, saying that he won't follow the rules and he keeps running away from home. He's put in the juvenile detention facility at age 13 over a weekend for a few days. And upon his release, he goes home. His mother doesn't pick him up. He finds a way home. And when he gets there, she refuses to let him in the house. She's locked the doors, forbidding him from the entrance. This is all in the records that you will have, members of the jury. Records indicate that when Franklin County Children's Services called Stephanie and asked why she wouldn't let him in the home, and if there was anyone else that could take him, she refused to provide Franklin County Children's Services with the phone numbers to other family members. Brian, without a father willing to take him in, is sent to foster care at age 13 for the 4th time. At the end of his 13th year, Brian's father, David Woodfork, finally makes an appearance and introduces himself to Franklin County Children's Services, the records will show, and the testimony will be. He introduces himself because, of course, Franklin County Children's Services has been trying to engage him for the last 13 years. But finally, at 13, he rises to the surface. They do a home visit, and this is in very, very quick fashion, just before Brian turns 14. Brian goes to live with his father at the end of 2001 for 4 days. For 4 whole days, he lives with his father. And then what happens? Brian then, without a father willing to keep him, is sent back to foster care. Brian at that point is classified a dependent child and placed under protective supervision of Franklin County Children's Services. He's then returned, as usual, by Franklin County Services a week later back to his mother. At 14, Brian once again is locked out of his mother and grandmother's house and left without food or money. You will have the juvenile court records that show that he stole from the local IGA store to get food because he was hungry. When Franklin County Services called his mom, she stated that her job at Burger King was more important and that she didn't care where Franklin County Services took Brian. She did not care. Brian, without a father willing to take him in, goes to foster care one more time. This time to Lancaster, Ohio. Mind you, members of the jury, every time there was a foster care placement, it was a different family. At age 14, the caseworker in Lancaster, Ohio, that being the Franklin County Children's Services caseworker, takes Brian to a hospital locally there in Lancaster and says that he needs an emergency psych eval. You see, Brian had been diagnosed previously with mental illness and he had medication. But when he was at his foster care parents', his mother had refused to give the foster care the leftover medicine that Brian had. He had gone weeks without his medication. So he needed an emergency psych eval. Later, Brian is returned to his mother by Franklin County Children's Services. When he's 14, later in that year, Brian is placed in a boot camp after saying inappropriate things to a little boy in the lobby of Franklin County Children's Services. And members of the jury, when I say inappropriate things, I mean inappropriate sexual things. Mr. Gotterdam and I are not going to hide behind the fact that our client has a criminal record and our client has a history of sexually acting out. The truth is, though, the records will show and the witnesses will state that this sexual acting out only took place after he was raped at age 12. After the boot camp, Brian is then sent directly from there to Buckeye Boys Ranch. At Buckeye Boys Ranch, Brian reports to having sexually acted out against others a number of times. He self-reports that. He begins to receive what they call sexual offender treatment. You will see that what he received at Buckeye Boys Ranch was not trauma-informed care. It was sex offender treatment. And there will be much more testimony about that as we get into the case, but I just want to say for now that the difference is this. The difference is when you have a child that has suffered the trauma that Brian has, it's asking him, what have you experienced versus what have you done wrong? At age 15, Stephanie loses custody of the twins and they go to their father. Franklin County Children's Services substantiates the abuse allegations made by the twins against Stephanie, that she would beat them with her fist, that she would tie phone books around their necks and have them run up and down stairs, and that they would withhold food from the children for long periods of time. The Franklin County Children's Services records indicate that she used those same forms of discipline against Brian. On a home visit when Brian's 15, Stephanie's seen drinking early in the afternoon. She continues then when Brian's about 15 and is at Buckeye Boys Ranch to fail drug test after drug test. Because you see, Franklin County Children's Services is still, for some reason, trying to give her a chance. She fails drug test after drug test, and Franklin County Children's Services petitions the court for a planned permanent living arrangement for Brian, because someone has to take this kid. Robin Smith then files for the custody of his children and obtains custody of them. No one files for custody of Brian Golsby, ever. When Brian is 16, Robin Smith gets full custody of his children. Stephanie is ordered to do a psych evaluation, and she's diagnosed with personality disorders with sadistic tendencies. I submit to you when Ron O'Brien wants to say that this is just the ordinary thing that all of us go through. Use your common sense. At 16, Brian is released from Buckeye Boys Ranch, and because his mother is unfit to take him, he's sent to a group home called Syntaxis. He runs away from Syntaxis many times, the evidence will show, and starts to pick up misdemeanor convictions. Criminal thefts here, truancy, all those kind of misdemeanor cases, absolutely. He's then sent from Syntaxis to another group home, ViaQuest. Again, runs away repeatedly, committing misdemeanor theft offenses. Neither his mother or father are willing to take him in, so he goes from the one group home to the next at 15, 16, and 17. Then at age 18, Brian is convicted of 2 receiving stolen properties. They're felonies of the 5th degree. They're the first felonies that he's committed at age 18. He's sent to DYS, which is essentially the kiddie jail here in the state of Ohio. It's where youth are sent that commit felony offenses that can't be sent to prison. He stays there for 3 years for 2 felonies of the 5th degree. He's there until his 21st birthday. While he's there, the records will show and the experts will testify that he was exposed to gang violence and not provided with, again, trauma-informed care. He comes out a worse person than he went in. At 22, Brian pleads guilty to a theft offense and received a prison sentence of 7 months. At 23, he pleads guilty to robbery and attempted rape and receives a sentence of 6 years. At 29, he's released from prison. After serving those 6 years, he's released on November of 2016. The incident in this case is February 8th of 2017. It's now March 16th of 2018, and he sits here as a 30-year-old man. This is the outline of the story of Brian Golsby. You are going to hear this story through evidence that Mr. Gotterdam and I will present you. Because although it is not our burden of proof with respect to the weighing, it is our burden to present to you the mitigation. And we will do that through witness testimony. You will hear from Stephanie Golsby's best friend. And you will hear from her and not Stephanie Golsby because the evidence will show that Stephanie died in January of this year while Brian was in jail. You will not hear from Brian's dad. You will not hear from any of Brian's relatives. And I want to manage your expectations now. The reason is because none of them are willing to come in on behalf of Brian. You will also hear from a psychologist with a specialty in trauma to talk to you about what Brian's story is, what trauma he has experienced, and why it's important that neither at Buckeye Boys Ranch nor at DYS was his counseling trauma-informed. It was just sex offender treatment. You will also hear from a transport deputy that will say that all the times he's brought Brian to court, he's never had any issues. You will hear from a records person that will tell you that during the year plus that Brian has been incarcerated in this case, under this stress at the Franklin County Jail, he has had 0 issues of incident. He's had no problems at all. You will also hear from a friend of Brian's that he was incarcerated with at DYS, who was a male and who is now a female. You will hear that they had a relationship. We will give you witness after witness over today, and then on Monday a forensic psychologist. They will tell you about his drug-dependent mother, how she abused drugs, his absent father, his physical and sexual abuse, and they will also talk to you about the systemic failures. And that's something that Mr. Gotterdam and I are going to talk to you about certainly throughout the witnesses and in my closing argument. Is because I know that Brian is on trial, but I am convinced that when you hear his story, the evidence will show that the system failed Brian, and also the system failed Reagan. Franklin County Children's Services, Department of Youth Services, his mother, the family system, the juvenile system. There were systemic failures here, and members of the jury, the judge is going to tell you that you can also consider mitigation in the first phase. And I will talk more about that in my closing argument, but for now I just say this to you. That questioning of mine of the APA officer about how they failed to properly monitor, they failed to drug test, they failed to revoke his supervision. They failed, and because they failed, that's a systemic failure. And that is part of why we are here today. Which brings me to something that the state of Ohio has casually said when the attorneys have been talking, and so I want to address it in case any one of you are thinking it. At no point ever, today, tomorrow, or Tuesday, when I make my closing argument, will I ever ask any of you to feel sorry for Brian. I don't expect you to think he's a nice guy. I'm not going to even try and sell that to you. I'm asking you to use your empathy to try and think about what it would be like to live a life that's that chaotic and unstable. Certainly I'm asking that. But here's what I'm not asking you to do. I'm not asking you to take the mitigation and the information that we present to you as an excuse as to why Brian did what he did on February 8th and 9th. I'm not, because there is no excuse for it. Mr. Gotterdam and I tried this case in the first phase, I think with class and dignity. I stood up here in closing argument and I conceded that TJ is Brian. We picked our battles with witnesses. And I hope you use that credibility, that street cred that we built up, and apply it here. Because I'm not offering you this information as an excuse, I'm offering it to you as an understanding of why that man sits at that table, why he acts like he does, why he is the man he is. I'm not asking you to like him. I'm not asking you to feel sorry for him or pity him. But I am asking you to use your empathy to try and feel what it would be like to live through what he has lived through. And so lastly, sort of on the theme of transparency and having some street cred, the judge did indicate to you that there are 4 sentencing options now in this case. And I know you all remember that because we had the board. We had the scales, and then there were the options on the left that said death, life in prison without parole, life 30, life 25. I'm just going to say to you now that while the state wants you to kill Brian, Mr. Gotterdam and I just ask you not to kill him. The options of life 25 and life 30, I'm never going to ask you to consider those in this case. I'm just going to ask you on behalf of Brian not to kill him. We will present to you evidence through witness testimony. You will have all those records I talked about on CD. There's over 1,000 pages of records. We will give all of this to you. I ask you to use your empathy as we do. Thank you.
All right, you can call your first witness. That's fine.